Hello and welcome to today's webinar. We've got a great session lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know using that same questions tool, and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded, and we will share a copy of the recording with you via email in the coming days. So, without further ado, I'd like to hand over to David Hall to get us started.
Well, good afternoon or good morning, wherever you might be. My name is David Hall. I'm the Chief Marketing Officer here at Hall Benefits Law, and I'm joined by two distinguished colleagues, Ann Tyler Hall and Tim Kennedy. Before I introduce the two of them who are our speakers today, I'd just like to tell you very briefly about the firm. We are a boutique ERISA law firm headquartered in Atlanta, Georgia. Tim Kennedy holds down the fort in our Pennsylvania office, and we're currently serving clients in 34 states. Just this week, we added a new client in Montana, which was our first, and so we're excited to continue to spread the footprint throughout the U.S. and hope to serve you in the future if you have needs. If you have questions during our presentation, please submit those via the questions portal in your control panel for GoToWebinar. We will see those questions as they come through. We will not be answering questions live simply because this is such a chock full of information type of webinar, but we will get back to you individually if you do submit a question. Lexology also will be providing a copy of the handouts from today's session. And if you look in the handouts, a copy of the slides from today's session, if you look in the handouts section of your control panel, there is a downloadable article about the Mental Health Parity Act, and that was just published this week by Law 360. We hope you will print that out and use that to your advantage. Please send your questions outside of today's presentation to admin@hallbenefitslaw.com. We do hope you will visit our website, check out our blogs, our monthly HR alerts, get a copy of Ann Tyler Hall's book in your hands. Reach out to the number on the slide here if you have any more specific questions about HBL and our team and how we're helping plan sponsors across the country. Without further ado, I will introduce our speaker. So if you could advance the slide, thank you. Ann Tyler Hall is our managing partner. She is the founding attorney here at HBL, and she is also the author of a book that we would love to get in your hands called Case Studies in ERISA: Why It Matters and How It Benefits You. This has been helpful to hundreds of plan sponsors as well as service providers across the country, getting a better understanding of who we are and our approach with clients. We are focused on proactive, relationship-driven employee benefits legal compliance, and the mission, vision, and values of the firm are driven by Ann Tyler Hall. Since the beginning of 2018, our team has avoided or abated more than $71 million in penalties for our clients. And we want you to know that we're growing, not because we're awesome, but because we're finding more ways to help more people. And as such, this year we were named to the Inc. 5000. So Ann Tyler Hall is going to be doing half of the presentation today, and we're proud to have her presenting. Tim Kennedy is our partner in Philadelphia. He has 18 plus years of large law firm experience, and then most recently, prior to joining the firm, was with a large global investment bank based in New York City. He works across all areas of ERISA, from health and welfare plans, retirement plans, executive compensation, you name it. Tim is your guy. So we're looking forward to hearing from Tim. And with that, Ann Tyler, I'm going to let you go through our agenda. I'm going to disappear, and I look forward to hopefully hearing from some of you. Give us a call or reach out by email. Thanks.
Thank you so much, David. I'm going to turn off my camera as we go through and focus on the presentation, and we'll come back on camera at the end. So thank you for joining us today. It has been a busy year for health and welfare benefits, legislation, new guidance. Since November 2020, we've seen a triad of regulations and new legislation that have significantly impacted health and welfare benefits, a myriad of different changes and complex, nuanced rules for plan sponsors and insurers and service providers to navigate. So with that, we'll jump into the agenda. We'll first cover the transparency and coverage requirements. These regulations were issued in November 2020. We'll then discuss the changes to health and welfare benefits and health and welfare plans under the Consolidated Appropriations Act, which was passed at the end of December 2020. And then we'll finally talk about the American Rescue Plan Act, passed in March of this year. And so we'll dive right into the transparency and coverage requirements. And these rules were passed again in November, on November 12th, 2020, almost exactly a year ago. They apply to group health plans and insurers in the individual and group markets. And they provide for a myriad of changes related to disclosures of cost-sharing information upon request to participants, beneficiaries, or enrollees. And specifically, the transparency and coverage requirements require certain cost information to be provided on public websites, on a public website in a machine-readable format. We'll dive into that. And then the transparency and coverage rules also require price comparison information to be made available to plan participants. Those rules apply beginning with the 2023 plan year, but we're going to cover those today as well. So transparency and coverage rules issued in November 2020. Subsequently, about 2 months ago, the departments jointly released a set of frequently asked questions that delayed some of the transparency and coverage rule requirements, or delayed enforcement, I should say. Also delayed some of the Consolidated Appropriations Act changes. So when you see a notation of the FAQ, that's a notation of we had an original effective date, but the FAQ may have delayed enforcement or delayed the effective date of some of these changes. So we've tried to note that as well. But the FAQ notes this August 2021 guidance from the departments as related to the transparency rules and the Consolidated Appropriations Act. So the first transparency and coverage requirement that we're going to discuss is the price transparency public disclosure rule. Now, these are ultimately obligations of the plan. This rule does not apply to grandfathered plans, accepted benefits, for example, standalone dental vision plans, retiree-only plans, health FSAs, HRAs, HSAs. Those are not subject to these requirements. But the FAQ did delay enforcement by 6 months to July 1st, 2020. This is welcome relief for covered plans. This is a new and significant extensive requirement for disclosure of specifically payment rates negotiated between the plan and in-network providers, historical pricing information showing unique allowed amounts and billed charges for covered items and services provided by out-of-network providers, and certain information on prescription drug pricing. And we'll talk about that in more detail, the prescription drug disclosures later in the presentation. But these are the general requirements for the public disclosure rules, the price transparency public disclosure rules. Covered plans must make publicly available these specific items. And then specifically as it relates to these disclosures, plans cannot charge a fee or require individuals to establish a user account or mandate the submission of personally identifiable information to access the files. The files must be updated monthly and reflect the date of the most recent update. And again, this is a significant change. This is a substantial new requirement, these public disclosure requirements and price transparency rules. We expect that plaintiffs' counsel may use this information to bring lawsuits against plans alleging that they're overcharging participants for health services. But you juxtapose this with that employers can also use this information to determine whether other similar employer plans are paying less for health services. And this is part of health plan decision makers, also known as health plan fiduciary. This is part of a fiduciary obligation to make sure that the plan is paying market rates with respect to the health services, the services provided for under the plan. Key takeaway for plan sponsors. As a plan sponsor, you should be requiring assurances from your third-party administrators. We're working with several of our clients right now to get assurances from the service providers, the third-party administrators, that they will comply with this new rule. Compliance with this rule requires information from your service providers and coordination and collaboration with your service providers. So now is open enrollment season for many plans. It may be renewal time for your service provider contracts, your third-party administrator contracts. You need to negotiate or make sure that there's a provision in your service provider agreement that contemplates compliance with these new public disclosure rules. Okay, next we're going to talk about the participant disclosure rules. So previously we talked about the public disclosure rules. These are specific to participants, and these rules generally apply January 1st, 2023. We'll talk about the staggered effective dates for these disclosures in the next slide. Just a note, the Consolidated Appropriations Act included a nearly duplicative provision to these participant disclosure rules, and so the departments are coordinating how they're going to combine these rules and coordinate these rules, but just a note around that. Covered plans under this participant disclosure rule must make publicly available to participants, beneficiaries, and enrollees the personalized out-of-pocket cost-sharing information and underlying negotiated rates for covered healthcare items and services. And this information must be provided through an internet-based self-service tool and or upon request in paper form. So there's a two-part rollout for these participant disclosure rules. The first set the first requirement applies beginning with the 2023 plan year, and it includes disclosure requirements for 500 items and services that are set forth in a table in the transparency rules, and then the remaining items and services covered by the plan must be available for disclosure for search by the first day of the plan year that begins in 2024. So again, significant changes to the disclosure requirements for health plans, for group health plans. Now is the time to begin to comply with these requirements. And note that the plans cannot charge a fee, and the information must be provided in plain language with respect to the cost of these various services. Once again, very important for plan sponsors to be working with their service providers, their third-party administrators, to contemplate compliance with this new rule. This will require coordination and collaboration between plan sponsors, plans, and the third-party administrators and service providers associated with the plan, engaged by the plan. With that, I will now turn it over to Tim Kennedy to talk through some of the changes to health and welfare benefit plans under the Consolidated Appropriations Act.
Great, thank you, Ann Tyler. Yeah, so the Consolidated Appropriations Act is a massive act. It's the largest bill ever passed by Congress in terms of length at nearly 5,600 pages. So it obviously covers a lot. Thankfully, not all of it relates to employee benefits, but there are provisions in there that relate to the benefit plans of our clients. and you can see them listed there, and that's what we're going to focus our discussion on right now. There's a prohibition on gag clauses. There's a continuity of coverage requirement. There's the price transparency and ID cards that need to be issued. There's broker comp transparency rules. Mental health parity has a new documentation of the comparative analysis that we're going to get into. There's a prohibition on surprise billing and relief for flexible spending accounts. So the first provision that we're going to talk about is the gag clause. The rules apply December 27th, 2020, but the agencies have said that they're not going to release guidance until later, and until then, plans are expected to adopt a good faith, reasonable interpretation of the gag clause and do their best to comply until the guidance does come out. And they tell us that the guidance won't be, the forthcoming guidance won't be relating to implementation. It'll only focus on this disclosure or attestation requirement that we're going to talk about that needs to be provided to the DOL and HHS. So what is the gag clause? Basically, the gag clause, the goal here is to increase transparency in pricing and quality information that's made available to the health care consumers and plan sponsors. So this provision of the CAA prohibits group health plans, health plan insurers, and issuers of individual health insurance coverage from entering into any service provider agreement that might restrict the plan's ability to do one of three things. A, obtain and disclose provider-specific cost or quality of care information. So this agreement can't prevent the plan from sharing that with plan sponsors, referring providers, and participants. It also cannot restrict the plan's ability to electronically access de-identified claims information in accordance with HIPAA, GINA, and the ADA. It further cannot prevent the plan from sharing any of that information with a business associate. So the takeaway that we're suggesting for plan sponsors is to engage counsel and start looking at your third-party administrator agreements and your other service provider agreements to make sure they don't contain any provision like this in them, and then be prepared in 2022 to attest to the fact that your service provider agreements don't prevent you from accessing this information. Okay, the next CAA provision is this continuity of coverage. These rules apply effective 1/1/22. Again, guidance is expected. So in the meantime, plans are expected to adopt this good faith and reasonable interpretation of the requirements. So under this requirement, when a provider is removed from a network, from a group health plans network, for whatever reason, the plan is obligated to notify certain participants receiving care from the provider that A, the provider is no longer part of the network. So this in-network provider is now an out-of-network provider for purposes of this participant. B, that the participant has the right to elect to continue receiving transitional care from the now out-of-network provider. And C, the plan will cover the transitional care provided by the former plan network at in-network levels. So this doesn't apply to every single participant. It only applies to participants who are in the process of being cared for certain conditions, certain complex and serious conditions, including inpatient treatment, non-elective surgery, pregnancy, and terminal illness. So anybody who's receiving that kind of care and has their in-network provider go out of network is required to get this notification and continue their care until the earlier of their treatment is terminated or 90 days. So here, the takeaway for the plan sponsor is to work with your TPA or your insurer to make sure that this notice is being prepared and identify who will distribute the notice at the right time, and identify and develop a process for tracking the transitional care period for each participant who might be affected by this rule. The next provision, CAA provision, is this price transparency ID card disclosures. These are effective as well on 1/1/22, and again here, guidance expected, so good faith, reasonable interpretation is expected. So these are the plan ID cards, and they have to have certain information on them. Most of them have this anyway, but now it's required to have, so it's worth looking at and making sure that they're updated. But the ID, whether it's in physical or electronic form, has to contain any deductibles and out-of-pocket maximum limits that apply to the participant's plan or coverage, a telephone number, and a web address for plan information. The frequently asked questions that Ann Tyler referred to earlier that were issued in August of 2021 clarified that it's okay to just list the main deductible and the main out-of-pocket maximum on that ID card. And you can also, as long as you can also, through the website or the telephone number there, as long as they can access the additional or different deductibles and out-of-pocket maximums, you should be fine according to that frequently asked questions. So our plan sponsor takeaway item, item here is to get assurances from your TPA or your insurer that their ID cards are going to be compliant with this new requirement. And again, that's effective 1/1/22. The next provision of the pharmacy benefits and drug cost reporting. This is a pretty dramatic new requirement. It was originally effective December 27 of this year, so very soon. Thankfully, through the facts, the deadline has been extended by 12 months because I think everybody recognized the complexity of this and that there needed to be more run-up time for it. But in that guidance, in that extension fact, the departments indicate that they strongly encourage, that's a quote from the fact, that plans begin immediately working to ensure that they're in position in December 2022 to report the required information for both 2020 and the 2021 plan years. So that's even though we have this delay, it's not a time to relax and sit back, I think is the message there. So what needs to be reported? Group health plans have to report certain information relating to their pharmacy spending and prescription drug. And they report this to the DOL, the IRS, and the HHS. The information that must be included is the plan year, and this is an annual requirement. So the plan year, the number of enrollees, and each state in which the plan is offered. You also need to report the top 50 prescription drugs, i.e. the most expensive prescription drugs that are paid for by the plan. You need to report the 50 brand drugs most frequently dispensed and the total number of paid claims for those drugs. You also need to report the 50 prescription drugs with the greatest increase in plan expenditure over the plan year compared to the prior plan year. You'll need to report the total spend on healthcare services by the plan broken into specific categories, for example, primary costs, hospital, pharmaceutical, other. You need to report the average monthly premium paid by the employer and the plan. And finally, you need to report the impact that rebates and fees paid by the plan's manufacturers, administrators, and service providers, what that impact those rebates had on premiums and out-of-pocket costs. So obviously a lot there, a lot to do. Thankfully, we have an extra 12 months to get ready for that. Our takeaway for plan sponsors is to review your agreements with your third-party administrators and your PBMs and ensure that they're ready to get this information out. The difficulty here, like we'll talk about with the Mental Health Parity Act and the comparative analysis documentation, is plans and plan sponsors don't typically have access to this information. So you're really going to need to rely on the TPAs and the PBMs, and you'll want to update those service agreements to make sure that they commit to doing this so that we're in compliance. The next provision under the CA is the broker comp transparency rules. This essentially, these are effective 12/27 of this year, so coming up. There's been no extension. It applies to all contracts or arrangements that are entered into, extended, or renewed on or after that date. But basically what it does is it takes the 408(b)(2) requirement of comp disclosure that applies on the pension and savings side of ERISA, and it now applies it to health insurance brokers and consultants. And 408(b)(2) is a statutory exemption that allows a plan to engage with a service provider and receive services, which would normally be a prohibited transaction under ERISA, but it allows you to do this provided you get this disclosure to the responsible plan fiduciary, and they approve that in advance. If you don't have that disclosure, the arrangement isn't considered reasonable, and the plan will have engaged in a prohibited transaction. The information that's required is the same as it's required on the pension and savings side. You need a description of the services, a description of all the covered comp. That includes both direct and indirect comp. Where applicable, you need a statement of fiduciary status. Consultants and brokers typically aren't fiduciaries, but to the extent they are, there needs to be a statement to that effect, and a statement as to where their fiduciary status and what action it covers. The Act includes a very broad definition of brokerage and services, and you can see those services there. I'm not going to go through them. I would say that this obligation is on the brokers and consultants, which sounds like good news, but again, the plan sponsor needs to reach out and make sure they're getting these disclosures in advance of any new updated or extended agreement, because if they don't get it, they will engage in a prohibited transaction. So yes, it's on the brokers and consultants, but the group health plan and the plan sponsors have an obligation and a very strong self-interest to get this information soon. So we recommend negotiating and reviewing the broker and consultant TBA agreements and get guarantees about their compliance, and sort of like a first action to take right now is reach out right away and ask for these compensation disclosures as soon as you can.
And Tim, I'll just add to that. That's something that we've been working with for our clients, drafting correspondence and requests for these disclosures. I did just want to add a few items with respect to this new 408(b)(2) disclosure requirement for brokerage and services to health plans. It also applies to health FSAs, HRAs. It doesn't require a contract with a service provider in order to find that a contract or arrangement exists with a covered plan. And the disclosure requirements apply even if some of the services are provided by entities in the control group, in the same control group, and it applies to services by subcontractors, payments made by brokers, for example, to subcontractors. Some additional disclosures include identification of the compensation based on a transaction basis, such as, is it commissions, a finder's fee, incentive compensation. And then significantly, Tim, and I just wanted to reiterate this point that you made, significant implications of responsibilities for plan sponsors. So if a plan sponsor requests this information, this compensation information, it is not disclosed timely, and the plan sponsor after 90 days still has not received these compensation disclosures, generally then plan sponsor should terminate the contract as part of their fiduciary obligation. And so really important.
Yeah.
Yeah. So very important to review these service agreements, particularly as they're being extended or renewed. But then separately, what we've been doing for our clients is drafting a request for this information separately to go ahead and demonstrate good faith effort at obtaining this information. Very important for health plan fiduciaries and decision makers, an important obligation.
Yeah, that's great. That's helpful, Tyler. That's right. I mean, you do want to terminate these agreements if you're not getting the disclosure. Otherwise, you're going to be engaging in a prohibited transaction and facing penalties. So there is an incentive there. And it is important to reach out, as we mentioned, and ask repeatedly for these disclosures if you're not getting them, so that if you're challenged, you can at least show the authorities that you tried to do your best to get these items. Good points, Ann Tyler. Thank you. Ann Tyler, that's the end. I think we're up against the Mental Health Parity Act, and I'll turn it over to you.
Great. Okay, so the mental health parity disclosure requirement may be the most significant change or new requirement that we've seen over the last year. And it became effective almost immediately after it became a new requirement. So if you don't have a disclosure, a MAPIA disclosure statement, then presumably you're already out of compliance as a plan sponsor. So a significant new requirement, and it became effective immediately, February 10th, 2021 for group health plans and insurers. And so this new disclosure, the Mental Health Parity and Addiction Act of 2008 required parity of coverage of, for instance, substance use disorder benefits and services in parity with general medical surgical services and benefits. And so the MAPIA requirement provides that upon request, plans must be able to provide data supporting the fact that the non-quantitative treatment limits for substance use disorder is comparable or no more stringently applied than for medical or surgery benefits. This was a new rule under the Consolidated Appropriations Act, and plans are required to perform and document comparative analyses of the design and application of these non-quantitative treatment limits. Group health plans are required to make this compliance documentation available to the DOL, HHS, or applicable state authority upon request. So there was no delay in this requirement under the FAQ. This became effective immediately. If you don't have this disclosure as a plan sponsor, it is imperative that you coordinate with your service providers to obtain this disclosure. We're working with plan sponsors currently to make sure that they have these disclosures and that they comply with the DOL's stated requirements with respect to the substance of the disclosure. Just to note, interestingly here too, one of our clients, we have received this disclosure from their service provider, but the NQTL, the basis plan on which they used for the NQTL disclosure was a fully insured standard plan product, and our client has a self-insured plan with individualized features. So that highlights, I think, some of the complexity and the nuance and the necessity to work with service providers and third-party administrators now to get this disclosure requirement, to have that in hand should the DOL, IRS, or HHS request a copy. And the Act requires that the departments request copies of at least 20 of these disclosures per year. Plan participants may also request this information now. So we've seen already a DOL disclosure requirement from a client on the East Coast. So the DOL, the departments are active in enforcement of this new requirement. If the group health plan's analysis does not demonstrate adequate compliance, The plan is provided with a 45-day correction period, which isn't long. These are nuanced, complex disclosure requirements. So 45 days correction period, again, this highlights the need to have this disclosure ready and to have already contemplated and worked through these disclosures with ERISA counsel and with your service providers and third-party administrators who are providing this information. If the plan cannot comply within that 45-day correction period, it must A, inform participants that the plan is not in compliance, and B, the DOL will identify non-compliant plans in its annual report to Congress. So significant implications. Also some penalties that may apply from the DOL and both the IRS. And so this is an important new rule that plan sponsors need to be working with counsel, service providers, TPAs to make sure that they are compliant and have this disclosure ready should the DOL, HHS, IRS come knocking, or a participant request this disclosure. Plan sponsor action item for plan sponsors that rely on their TPAs to establish and implement the NQTLs. Should require and inquire that what they are doing to prepare for this transparency requirement. And then, as I alluded to earlier, we're working with several clients to not only ensure that we have a copy in hand of this disclosure requirement, but ensure that it's comprehensive and responsive to the DOL's stated specifics with respect to the disclosure. The Biden administration has indicated that MAPIA compliance with the mental health parity rules is a top priority. Recently, the acting assistant secretary of labor stated enforcing the MAPIA is a very high priority for DOL and has been since the beginning of this administration. The secretary of labor views this as our top health enforcement priority for EBSA. So I think we can expect that the DOL, certainly IRS, HHS, will be monitoring and enforcing these disclosure requirements very carefully and actively. This slide provides an overview of an NQTL. It refers to any benefit limit that a group health plan imposes on items and services that are not a specific monetary or visit limitation. There's some examples. And then just to note the exposure for non-compliance. DOL is prioritizing MAPIA enforcement. We're seeing this in claims and lawsuits and settlements. United Health recently settled a MAPIA claim with the DOL to the tune of over $16 million. And a promise to take corrective actions to resolve violations of the MAPIA. This is significant. DOL suing a major insurer. So again, this decision is viewed as part of the Biden administration's making good on its promise to enforce parity. This is a big ticket issue. Also, Cigna sued by a plan participant recently, alleging MAPIA coverage violations. A litany of different lawsuits have been filed against purported non-compliant MAPIA plans. There's another MAPIA lawsuit. This involved in 2017 against a self-insured medical plan for union employees. That plan recently settled for $1.7 million, rather than defending allegations that it improperly refused treatment for autism and other developmental conditions. Tim and I wrote an article recently for Law 360 where we outline and highlight some of these recent lawsuits, again highlighting why MAPIA compliance is so important. It has been explicitly stated as a top priority for the Biden administration.
And Tyler, if I could just jump in on that MAPIA issue real fast. We're seeing difficulty, especially for self-funded group health plans, self-insured plans. They don't have access to the information they need to complete the comparative analysis. So again, it's important, especially for self-funded plan sponsors, to try to get on top of this and work with their TPA to get this done.
Yeah, great point, Tim. I mean, plans have little or no knowledge of plan operations and access to the plan information needed to comply. So heavy reliance upon third-party administrators and service providers. Once again, I think this highlights the year to review your service provider agreements, your third-party administrator agreements. Very important that these provisions and that you have assurances from service providers that they are going to work to comply or are going to comply with this myriad of new rules and requirements. Okay, we'll jump in now to the prohibition on surprise billing. These rules are generally effective January 1, 2022, just a few months out from that. And generally, the prohibition on surprise billing provides that patients cannot be balance billed by an out-of-network provider for ancillary services or emergency services. Accepted benefits are excluded from this requirement. We've gotten 2 sets of interim final rules. I'll talk about those in later slides. But just a general overview, this No Surprises Act expands the emergency services definition. It's interpreted very broadly. It applies to the initial evaluation until patient stabilization, when specifically they can consent to a transfer to an in-network facility. This protection applies to both out-of-network facilities, out-of-network providers, and air ambulance services. And given an example in this last bullet of post-stabilization services, and again, to highlight the expansive definition of what is an emergency service, and it includes comprehensive post-stabilization services. We got our first set of interim final rules in July, and gave us some further gloss on this No Surprises Act. It specifically provides that there's a prohibition on surprise medical bills for emergency services, air ambulance services provided by out-of-network providers, and non-emergency services provided by out-of-network providers at in-network facilities in certain circumstances. If a plan covers any benefits for emergency services, the Part 1 IFR makes clear that those services must be covered, A, without any prior authorization, B, regardless of whether the provider is an in-network provider or an in-network emergency facility, and C, regardless of any other term or condition of the plan or coverage other than the exclusion or coordination of benefits and the waiting periods. And again, emergency services defined broadly to include services in an emergency department of a hospital or an independent freestanding emergency department, as well as post-stabilization services. The Part 1 IFR also limits cost sharing for out-of-network services and requires that cost sharing to count toward any in-network deductibles and out-of-pocket maximum. So generally these rules apply beginning of next year, January 1, 2022. Additionally, patients can be balance billed for non-emergency services performed at an in-network facility by an out-of-network provider, but there has to be a notice and consent. Now, patients can waive these protections if the consent, by consent, if notified at least 72 hours in advance of the care. If the appointment is made less than 72 hours in advance, the notice and consent must be provided at least 3 hours before the appointment and must include A, a good faith estimate for the charges for the services in writing, B, a list of in-network providers at the facility who could perform the services, C, information about any prior authorization or care management requirements, and D, consent must be signed by the participant and a copy provided to the participant through mail or email. And then additionally, we got guidance that group health plans must report air ambulance services claims data claims data for 2 years. So beginning in 2022 and again in 2023, group health plans must report air ambulance services claims data as part of this prohibition on surprise billing. Also, a requirement, an advanced explanation of benefits. These provisions apply with respect to plan years beginning on or after January 1, 2022, but the FAQ acknowledged that due to the complexity of transferring all the required data between entities, the departments will defer the enforcement of this rule until regulations are issued. But important for plan sponsors and plans to understand what these new requirements are and what their obligations will be for these advanced explanation of benefits. So specifically, providers and facilities are required upon an individual's scheduling of services to inquire if the individual is enrolled in a health plan and to provide a notification of a good faith estimate of the expected charges for furnishing the scheduled item or service. And then upon receiving a good faith estimate, a health plan then, the health plan, the plan sponsor is upon request required to send the enrollee an advanced explanation of benefits that provides the prospective patient with A, the cost sharing, the costs and cost sharing, B, the provider, whether the provider's furnishing the items or services is in network or out of network, and how to find, C, how to find in-network providers. Additionally, the prohibition on surprise billing requires for accuracy of provider directory, and plans must update and verify the accuracy of the provider directory information at least every 90 days and establish a protocol for responding to requests by telephone from enrollees about a provider's network participation status within 1 business day, and then also update the database within 2 business days of receipt of information from the provider facility. So significant new requirements with respect to provider directory accuracy. Just a note that if an enrollee is furnished information that a provider is in network, and in fact they are not, they are out of network, but they were provided incorrect information, then generally the in-network cost sharing will apply because the participant was not provided the accurate information. So that could be a costly mistake, an important item for plan sponsors, for plans to be aware of, that the provider directories must be up to date, they must be accurate, and if they aren't, then it's the plan's obligation to cover any out-of-network disparity in cost sharing. Once again, plan sponsor action item, review TPA agreements to ensure that the TPAs will keep directories updated and will indemnify the plan sponsor if there are any increased claim costs due to an inaccurate provider directory. Second set of interim final rules released on September 30th, and these specifically contemplated the independent dispute resolution process for the payment of out-of-network providers. So some new guidance, new rules for an IDR process for payment to out-of-network providers. And specifically, parties must exhaust a 30-day open negotiation period prior to initiating the federal IDR process. The parties may select a certified IDR entity, but if they do not, the departments will. And then within 10 business days of selection of the IDR entity, each party must submit to the certified IDR entity an offer of payment amount for the item in dispute. Additionally, these IFR rules provided for rules and requirements around good faith estimates for uninsured or self-pay individuals, and those are enumerated at the bottom of the slide. They also provide for a patient-provider dispute resolution process. And then importantly for plan sponsors, expanded rights to the external review that was part of the ACA, the Affordable Care Act. And so the second set of IFRs amend the final rules issued by the departments in 2015 related to external review, and they amend them to expand the scope of an adverse benefit determination, that definition of an adverse benefit determination, to include determinations that involve whether a plan is in compliance with the surprise billing and cost sharing protections under the No Surprises Act. So a significant expansion then of the external review rules that were originally included under the Affordable Care Act. With that, I will turn it over to Tim to talk through the
Great.
FSA.
Thank you, Tyler. Sorry. Okay, this is the last provision of the CAA that we're going to talk about, but this relates to the flexible spending account relief that was granted. During COVID, participants were having a hard time spending the amounts they had in their health FSA and dependent care FSAs, especially their dependent care FSAs, because daycares and nurseries and things like that were closed. So as most of you probably know, these FSAs have a pretty harsh use it or lose it typically. If you don't use the amounts in your FSA, they're gone. So you put them in, you don't use them, you lose them. So this relief came in and gave plan sponsors the option. All of this is optional. You don't have to do it, but if you did do it, you're going to want to have amendments to the plan in place. But the first thing they provided was they allowed participants to carry over their entire unused balance. You could take your unused balance from 2020 into 2021, and you could take your 2021 balance into 2022. Under the old rules, if you had a health FSA, the only amount you could carry over was limited to 550, and you weren't allowed to carry over any amounts for a dependent care FSA. So this is a pretty generous thing. If a plan sponsor wanted to do this, they need to have a timely amendment, which we'll talk about in a second. The second thing a plan sponsor could do, again optional, is, and it's one or the other. You can't have the carryover and this next feature. If you don't want to do the carryover, you could have a grace period. The normal grace period for flexible spending accounts is 2.5 months following the plan year, in which you can incur and get reimbursement for expenses. Under this new grace period, temporary, optional, you have 12 months. So you have 12 months following the plan year in which to spend your DCAP or health FSA amounts. Effectively from the participant standpoint, there's no difference whether the employer allows the carryover or the grace period, except to the extent that they might terminate employment in the middle of the year, and we'll talk about that in the next page here. So the next page, I know we're running out of time, I know we want to get everybody out of here in an hour, is this spend down feature. Again, optional. Employers could allow employees who terminate in 20 or 21 to continue to spend their unused balance, incur and spend down their unused balances for not just the remainder of the plan year, but also any grace period, including a 12-month grace period if that was elected. And they can do that without a Cobra election, which is what you would otherwise need for a health FSA. Finally, the relief allows an increase in the dependent care age from 13 to 14. And just as a reminder, if you have a dependent participant child who turned age 13, you could get reimbursement for those expenses up to the month in which they turned 13. That's now age 14. So in my example there, if a child turns age 14 in August 2020, you can submit claims through August 2021, but you can't, you're ineligible for any months after that. Okay, that concludes the CAA portion of it. There is also under the FSA relief, you can also, it's not in our slides, but I want to mention it. You can allow participants to make a mid-year election without a change in status event if they want to enroll or disenroll with a flexible spending account, or if they want to increase or decrease those amounts. Okay, the next thing is the American Rescue Act of 2021. This one most notably provided, and this is already past the period, but it's worth mentioning really quickly. It provided for the 6-month Cobra premium subsidy and an increase in the dependent care FSA exclusion limits. Just really quickly, the Cobra subsidy, it was a mandate. It's already passed. Employers were required to provide 100% premium subsidy for Cobra premiums that fell between the 6-month period, April 1, 2021 through September 30th. So anybody who had Cobra during that period had, from their perspective, their premium paid for by their employer. There were additional notice requirements or special notice requirements that were attached to that. You see them there at the bottom. Again, you've either done it or not. Hopefully you've all done it, and those notices have been distributed. It's now too late, but those notices should have gone out. Probably the more relevant piece of this Cobra subsidy portion is the tax credit that's available to the employers that subsidize the premiums for those 6 months. Essentially, it's time now for those employers to claim their credit, and they do this through an offset against the plan sponsor's Medicare tax liability, and you do this through Form 941. If your credit is less than the Medicare tax liability, then you report that credit, and you can anticipate your credit by just deducting the amount you would otherwise owe for the Medicare tax liability. But if your credit, if the amount you spend on the premium subsidies exceeds that Medicare tax liability, you can again anticipate it and deduct the entire amount. But you can also you will also be eligible for a refund from the government for the excess amount, and you can get an advance on that refund. And the way you do that is through a Form 7200. There's that also the mid-year election change status. That in connection with that Cobra premium subsidy, you could make a change in your coverage or options under the group health plan without a change in status event. This deadline here, I just noted, it's a notice 2021-58. We're running out of time. It just came out less than 2 weeks ago. There is a lot to it, a lot to untangle, but essentially for folks making their initial Cobra premium payment, they now have a year and 105 days. If they made it outside their initial 60-day notice period, and if they made it within the initial 60-day period, they have a year and 45 days from the date the Cobra they made the Cobra election. And in terms of the initial Cobra election, they need to make that by 1 year and 60 days after they get the Cobra election notice, or the end of the outbreak period, which still has not occurred. Again, a lot to untangle there. Finally, this temporary increase to the dependent care, not the health FSA contribution limits. Normally, currently, it's $2,500 in the case of single or separate return, $5,000 for married filing jointly. Both of those have been increased to $10,500 and $5,250 respectively. Again, it's optional, it's permissive. If you wanted to do this, and this only applies to the 2021 calendar year, if you wanted to do this, you have until the end of next year, December 31, 2022, to put in place that amendment. In the meantime, you ought to be, operating everything consistent with, the amendment, the amendment to come terms. And with that, I think we conclude our presentation, and I'll turn it back to you, Lucy, I think. Thank you, everybody.
Thank you very much. Unfortunately, the clock is against us, and I would just like to thank our wonderful speakers from Hall Benefits Law today for such an interesting and informative presentation. A big thank you as well to all of our attendees for taking the time to join us today. As a reminder, we will be sharing a copy of the recording along with the slides and the handout via email in the next few days. Once again, Thank you everybody for joining us, and we hope to see you again soon. Goodbye.
Thank you.